The HOA filed foreclosure proceedings against my fully paid home over a $312 assessment I never received notice about. They threatened to auction my property within 30 days, claiming unpaid dues justified immediate seizure under their governing authority. But when I subpoenaed their incorporation documents before court, the truth detonated everything they built over 17 years. The HOA had never legally existed, yet collected millions, imposed fines, and foreclosed homes without lawful authority whatsoever. My name is Adam Carter, 55 years old, commercial loan officer analyzing corporate structures and compliance documents for 26 years. I understand incorporation requirements, state registrations, how legal standing determines whether an entity can enforce contracts or debts. I purchased my Riverside Gardens home outside Knoxville 12 years ago with cash. It's the 3-bedroom ranch overlooked mountains with a creek running behind the property. No mortgage, no liens, completely owned, free and clear. Monthly HOA dues were $65 covering pool maintenance and landscaping. I set automatic payments and never missed one for 11 consecutive years. Then in March, a certified letter from Blackwell & Associates arrived unexpectedly. It read, "Notice of intent to foreclose for non-payment of $312 special assessment." The amount allegedly dated back to November 2023 for emergency drainage repairs. I never received any notice of that assessment. My bank records showed uninterrupted automatic payments every single month. There was no $312 charge, no reminder, no warning. I immediately called Summit Property Management and requested clarification. Patricia Ross claimed notices were mailed to all homeowners on record. I requested certified mail proof, delivery confirmation, any documentation specifically addressed to me. She admitted they used regular mail only. I explained legal notice requires proof when property rights are threatened. She responded foreclosure would proceed unless payment was received immediately. Something felt deeply wrong beyond a missing letter. I contacted my attorney, Robert Matthews, specializing in HOA disputes. Robert reviewed the notice and immediately spotted statutory deficiencies under Tennessee foreclosure law. Required cure periods were missing, along with redemption rights and documented proof of proper notice. He advised formally disputing the assessment and demanding complete documentation, sent certified letters requesting assessment calculations, authorization records, and incorporation documents establishing legal standing. 2 weeks later, Blackwell responded dismissively, demanding $487, including late fees and interest. They provided zero supporting documentation for any claimed authority. Robert warned, paying would validate improper foreclosure procedures. We prepared to fight in court instead. The case was filed in Knox County Circuit Court for June hearing. Robert filed comprehensive responses, challenging notice, procedure, and legal standing. He submitted discovery, demanding articles of incorporation and registration proof. Dennis Blackwell resisted, calling requests overly broad and burdensome. Judge Patricia Gwynn ordered full production within 30 days. What they produced was revealing for what it lacked. Bylaws were included, financial summaries were included, homeowner lists were included. Articles of incorporation were completely absent. Robert immediately searched the state corporate database for Riverside Gardens HOA. No results under exact name or variations. No results under registered agent listed in bylaws. The HOA was not incorporated at all. Operating 17 years did not equal lawful formation. Without incorporation, they lacked legal entity status. Without entity status, they lacked standing to foreclose property. We filed emergency motion requiring proof before foreclosure hearing could proceed. Blackwell argued homeowner consent created authority through estoppel. Judge Gwynn rejected that reasoning at preliminary hearing. She asked directly whether articles of incorporation existed. Blackwell admitted they were unable to locate such documents. The courtroom fell silent as implications settled heavily. Judge Gwynn continued proceedings 30 days demanding incorporation proof or dismissal with prejudice. I left court realizing this issue extended beyond my case. Over the next month, I investigated Riverside Gardens history. Developer Marcus Green created bylaws in 2007, but never incorporated association. Residents unknowingly paid dues to unregistered unincorporated association for 17 years. Records showed 6 prior foreclosures executed under non-existent corporate authority. I contacted former homeowner Jennifer Wallace about her 2018 foreclosure. She lost her home over alleged $1,800 unpaid dues during divorce. Her property worth $200,000 sold at auction for $80,000. She never knew the HOA lacked legal existence. At continued hearing, Blackwell again failed producing incorporation documents. Judge Gwynn dismissed the foreclosure case against me with prejudice immediately. She ruled non-existent entities cannot invoke statutory foreclosure powers. My home was safe, but consequences were just beginning. Robert initiated class action representing residents and foreclosure victims. Lawsuit alleged fraud, unjust enrichment, and illegal foreclosure practices. Defendants included board members, Summit Property Management, and Dennis Blackwell personally. Media coverage exposed Phantom HOA operating 17 years without registration. Discovery revealed management collected over $2.4 million in dues. Internal emails showed board members warned about incorporation deficiencies years earlier. They ignored warnings and continued enforcing fines and restrictions. Insurance carriers became involved under malpractice and management liability policies. Settlement negotiations intensified after damaging depositions surfaced publicly. 18 months later, comprehensive settlement agreement was finalized. Total recovery reached approximately $2.8 million for affected residents. Current homeowners received reimbursement of prior dues payments. Foreclosure victims received substantial compensatory damages for lost equity. Legal fees were covered separately with a negotiated settlement structure. The original Riverside Gardens HOA was formally dissolved thereafter. Covenants became unenforceable, absent valid corporate entity to administer them. Residents debated forming new properly incorporated association voluntarily. Approximately 60% joined newly registered community organization. I verified incorporation documents personally before joining. Jennifer Wallace received $147,000 and purchased home elsewhere without HOA. 5 years later, my home remains fully paid and lien-free. The $312 assessment nearly costing everything unraveled 17 years of illegality. Demanding documentation, exposed systemic negligence and possible fraud. Most people pay questionable fees, simply avoiding confrontation. But authority without legal foundation collapses when challenged with evidence. Sometimes the most powerful words in any courtroom are simple: "Show me proof of your legal authority."